All right, good morning everyone. For those of you I haven't greeted this morning, good morning. I'm happy to be here this morning with you, and I hope to share some of my knowledge with you, and I hope that you'll find it useful. I thought perhaps before we proceed, you know who I am. I am a litigant in the High Court, mostly. I have about 14 years experience, so I know a bit about civil procedure. I used to be a JTC lecturer. Some of you may have been in my lectures there, so you may remember me from then. I thought perhaps before we proceed, a good point of departure for me, just to understand the audience and to understand the level of lecturing that I should be doing with you. So we've got quite a mix here this morning, and I think some of you have had some experience with civil, and some even in the High Court, and some of you have done JTC, so you have a basic understanding, and some of you have not. So those of you who may be at a higher level of understanding of civil procedure in the High Court already, please bear with me. I'm going to present the lecture so that everyone's captured and everyone is brought to the same page. So it might be that you hear some of these things for the second or third or fourth time even. I suppose there's never enough times to hear these things. What I propose to do, I understand that you've all received a program, and I'm going to try and follow the program, but here and there I'm going to have to deviate in order to deal with issues that are pertinent, and I think that that tie in, and I'll then again get back to it when it's time to present that part of the course. The subject today is pleadings in general, but what I want to do is just to start with issues that you need to consider from a litigant's point of view, but these will also be issues from a judge's point of view that are pertinent and important when a matter comes to you and you're going through pleadings. So what I want to do is deal with a number of issues like causes of action, jurisdiction, and locus standi, and then we'll go on to action proceedings. Now I'll be doing the action proceedings, and Natasha Bassing-Swade will be doing the motion proceedings, and she'll be dealing with what the pertinent issues are there. So then we'll go over and we'll deal with pleadings, contents and service of the summons, joinder, the plea, claim in reconvention, replication, then obviously pleadings after replication. I'll deal with you briefly regarding that. You won't find issues like joinder and some of the others I'll show you in a moment, consolidation, security for costs, and absolution. You won't find them in your course outline, but I do think these are pertinent issues which tie in with what we're doing here, and pertinent issues that I just want to deal with you and discuss with you so that you're on the same page. All right, just an overview. Of course, in the High Court, as with any court, I mean, there's statute. It's unlike the Magistrates Court, which is a creature of statute and gets its power and jurisdiction from a statute. The High Court is different, as you all know. It has inherent jurisdiction, so it's not guided. Its jurisdiction is not guided by statute. That doesn't mean that statute isn't important. So, of course, you need to have regard to the High Court Act. It is listed in your course program. There are a number of things that you have to have a look at. Particularly, you have to be well versed with the High Court Act, with the Supreme Court Act, of course, and the Supreme Court rules, although we're not dealing with the Supreme Court here, but you'll need to know those. But High Court Act, High Court rules, practice directions. These are very important. They guide how procedure in the High Court, civil procedure in the High Court is done, and it's very important for you to be well versed. Now, when I say well versed, I'm not sure what the position is, but I'm fairly certain you'll be able to take these into your examination, because there's no purpose in actually just memorizing them. The idea is to read the rules and to understand them and to know how to apply them in practice, because that really is what's going to guide your approach to practice in the High Court. So rules and practice directions, very important. Then, of course, statutes and common law statutes, those applicable to Namibia as a whole, but then particularly the High Court Act insofar as civil procedure is concerned, and then understand the common law in Namibia insofar as it hasn't been amended by statute, is still applicable and still directs. A lot of substantive and procedural law in Namibia is still guided by the common law, especially when you deal with things like exceptions, Rule 30s, summary judgments. Those things are all, it's not written down somewhere. It's the common law and then the body of case law that we have. And in Namibia, fortunately, we have a quality bench at the High Court, and we are developing our own pool of cases dealing with these issues that are applicable to Namibia and to a Namibian environment. So yes, that it's also important to know. As you may or may not be aware, we have e-Justice, which was launched a while back. I think it was a bit of a difficult time for practitioners, much like it was for everyone at the High Court, but I think the system is running smoothly. So now you no longer take your printed version of your summons and you run across to the High Court and you have it issued and you run around to everyone. It's all electronically done. I'm sure you will get an introduction to the system. I won't say that I'm an expert on the e-Justice system, but someone, I suppose, will introduce you to that system. And then, of course, you still have the old paper files. That'll be phased out over a number of years because you can't convert the paper files to e-Justice files. So those are still running. So you'll have your court files and you'll have your e-Justice files, which is meant to be a paperless approach to litigation. And it also saves a few trees. All right, Rule 6, return. So when you start, when any process is started, you'll start with the rules, and in particular Rule 6. I take it you all have a copy of the rules handy. I think you were requested to bring a copy. I have mine electronically, so let me just open it. Time with you on issues such as the registrar's office hours and rules of the court and practice directions, other than what I've just told you, because these are really the things that you can read in the rules and they speak for themselves, and I don't think I need to deal with that. Particulars of litigant to be provided. So now you're coming to the court process before judicial case management. So in action proceedings, they are done in 3 parts, and we'll get to that slide in a moment. It's you have your pre-case management process, which is before close of pleadings, although in action proceedings, unlike motion proceedings, except for reviews, so it's a typical legal issue but in action proceedings there is a component of case management already within the first part before close of pleadings. That's case planning, but with case planning we'll deal with in a moment. So it's not that case management is sort of taken out of the pleading stage and then it's just parked when pleadings are closed. It really is a fluent process that runs, and although I'll be dealing with case management as a separate unit in the lecture, please remember that case management starts really the moment a notice of intention to defend is filed. Then already the file is allocated to a judge, and then already case management starts, even though it's in case planning phase. So this is an overriding principle that guides all defendant matters in the High Court. There's no exception. And we're dealing specifically with actions. So although, please keep in mind, although I'm speaking of case planning under the case management part of the lecture, it really already forms part of the system or the process from the action becoming defended. So then it's already allocated to a judge, and then already you find case planning, status hearings, etc. So we'll get to that in a moment. But that's the first part. Then pleadings close. So parties exchange their pleadings, and in the pleadings they set out what their purpose are. So the litigant, the plaintiff says, this is what I want, and the defendant says, I'm defending this because of this, that, and the other, and they exchange pleadings, and then pleadings close. I'll deal with you or later today about when pleadings close and how they close, etc., etc. But that really is the first part. Then pleadings close, then comes preparation for trial and case management proper, because then you come to managing the case for it to go to trial. And then you have the trial, and after trial, when you have judgment, you have execution, which really isn't something that the judges are dealing with, so I won't deal with that. It's not part of the course today. But those are the processes that a civil action goes through. All right, so particulars of litigant, this is Rule 6. It was changed from the previous rules. It was one of the more significant changes in start commencing an action. And then it says there's a form prescribed, and litigants must then, or the lawyers must then file a Rule 6 return together with the summons that they issue in order to set out the particulars of the litigant. Previously, what was required was a power of attorney. The practitioners and litigants had to file a power of attorney when acting through a legal practitioner. That system has not been abolished in the sense that you no longer need a power of attorney. It's always safe for practitioners to have a power of attorney, but you can keep it on your file, so you no longer file it with the High Court as you did previously under the previous rules. All right, so a first consideration, and I think an important one that you need to consider, is causes of action. Now, I think any practitioner and any judge for that matter can start by having AMLA's precedents of pleadings. Now, I'm by no means suggesting that what's in this book is an exhaustive list of causes of action, or that it really is the epiphany of good drafting. Far from it. I'm not one, when it comes to legal drafting, to look at a precedent and copy and paste, but it gives you a good idea of what causes of action there are, and the South African case law. Then, of course, when you look at the basic principles as set out, of course it's important to then look at Namibian case law and how that's been updated, because this book isn't updated necessarily by Namibian case law. So, but AMLA's precedents of pleadings gives you a good idea of the causes of action that one finds, because of course in any civil action you have to set out your cause of action. I suppose it's much like criminal law. When someone is charged with a crime, it must fit into the crimes that are prescribed. I mean, someone must be guilty of something, having transgressed the law and having been guilty of some kind of a criminal offence. So causes of action would be either in delict or in contract, or it would be, for instance, enrichment, etc., etc. There's no exhaustive list, so no one can provide you a whole list and say these are all the crimes that are there in Namibia. Not the same with causes of action. They're fluid, they change, but generally you'd be able to fit them into a certain area of the law, and you should be able to. And most of them are actually fairly established, and you'll be able to find in AMLA's at least a reference to it, and you'll be able to establish this is the cause of action, so these are the allegations that are necessary in order to sustain such a cause of action. It's very important to establish whether a cause of action actually exists in law, of course, because someone might feel aggrieved, but that doesn't mean in law that they actually have a cause of action. So, for instance, to try and explain that, say, for instance, my husband, to whom I married out of community of property, he drives to work one morning and a car comes from the side, disobeys a traffic sign and rams into the side of his car that belongs to him. And he's injured, and I feel aggrieved, and then I sue because he's, say, the breadwinner, and his car's been damaged. So now I sue for loss of income, and I sue for the damaged car. Of course, I'll have a cause of action for loss of income insofar as he was the breadwinner and he was actually supporting me or our minor children. But for the damage to his car, I won't have a cause of action, because, and I won't have locus standi, because the car doesn't belong to me and we married out of community of property, so our estates are different. Does that make sense to you? So I'll be able to sue in one instance for the damage to his injury, but not for the damage to the car. That he must sue, or his curator if someone is appointed, etc., etc. So that's basically the difference between having a cause of action and not having a cause of action in law. So I may feel aggrieved by the fact that my husband's car has been damaged, but it's not my car and we married out of community of property, just by a simple example. And then also, it's important to know and establish in certain causes of action a letter of demand may be required. For instance, by statutes, if you want to sue the Namibian police, the Minister of Safety and Security, then you need to first send out a letter of demand. Failure to do so will mean that you don't have a cause of action yet, because it's premature, because you haven't complied with the requirement to file a letter of demand or send a letter of demand. And then also in instances, for instance, where there is a contract and it's a contractual claim and there's a breach, and the contract between the parties requires that a party be placed in mora before breach clause can be invoked. Then to proceed with a breach clause without having placed the party in mora may cause difficulties. So these are more or less the principles that you need to consider when even before proceeding with an action, with a summons, these are issues that are important. And from a judge's point of view, these are issues that are important when the matter comes to you and you deal with the matter and the particulars of claim, what it is that you're dealing with, particularly, I suppose, when you're dealing with default judgments, because there's no opposing party for whatever reason, and a judge needs to be mindful of these issues in order to see whether he or she can actually grant default judgment despite there being no notice of intention to defend. Any questions thus far? Anything that's unclear?
Regarding the letter of the demand, this last instance that you mentioned, can you just clarify that again? Is it that some contracts may require it and others may not? So it depends on whether that is a clause in the contract.
Absolutely. So what you need to do, say for instance there's an action, a summons, there's no notice of intention to defend, and it's, for instance, it's a summons based on a claim based on contract, breach of contract. Of course, in terms of Rule 45, which we'll get to in a moment, the written contract must be attached to the particulars of claim, otherwise you can't, it's a not compliance with the rules. And then you'll have to have a look at the agreement to see whether the agreement requires the party now before you to have had to call the other party and by way of letter and say that you are now in breach, in mora, and I give you 14 days to remedy or whatever. And only in that instance will your right arise, because contractually it doesn't arise until you've done that. Even more so, a necessary allegation in that instance would be, for instance, to say that notice was given in terms of the agreement for the breach wasn't remedied, persisted with, and therefore I claim whatever it is that I'm claiming. More importantly, as I said, for instance, if you're suing the Namibian police for wrongful arrest or whatever it is that you're suing them civilly for, you'll have to file a letter of demand. And remember, there's a different prescription period. It's 12 months. So you need to file that letter of demand before the 12-month period from when the cause of action arose. And for wrongful arrest, the cause of action doesn't arise once there's an acquittal or a withdrawal. Wrongful arrest happens there and then. So please remember that it's different for malicious prosecution, but for wrongful arrest, the cause of action arises. That's just a bit of trivia. Arises from the moment that the wrongful arrest is executed. And for that, you'll need to file a letter of demand, and failure to do that would mean, of course, the minister can waive that right, but you guided by statute there, and it's important to know that for that cause of action, certain things need to be in place. So that's why I'm saying be mindful of the cause of action, and when you're faced with the particulars of claim, have a look at what it's about, and make sure that you read up on the law relating to that cause of action before you do anything else, and particularly in instances where there's no opposing litigant and you're requested to grant default judgment. Because a default judgment incorrectly granted is really a short-lived issue, victory and a short-lived judgment, because it's of course subject to review and rescission. Yes, that will depend on the wording of the agreement. So you'll have to look at the actual agreement and you'll have to establish whether the agreement requires that. So there's no exhaustive list, because parties set up agreements as they see fit, and it may be that in certain instances it says, if you're in breach, I'll cancel, and that's fine, then you don't need a letter of demand. But it may be that in certain instances the contract says when a party is in breach, the other party must first send a letter saying, sir, you are in breach of the agreement, I'm giving you 14 days to remedy, failing which I'm going to cancel. Yes, the cause of action, of course, will dictate what course a party will follow. So that's more from a litigant's point of view. It will obviously dictate whether you sue for contractual damages or in delict, or how you proceed with your particulars. And in a particulars of claim, as a general point of departure, and this is true every time, all the time, there's no exception, all the necessary allegations to sustain a cause of action must be made in your particulars of claim. Failure to do so will render it excipiable, and it will probably lead to absolution or a judge refusing to grant default judgment, because you need to make all the allegations. When it's a default judgment, of course, you don't need to prove all these allegations, but when you proceed to trial, there's of course this onus of proof, and he who alleges needs to prove. There are certain instances of reverse onus, but later in your course, not with me, but with one of the other presenters, you'll be dealing with the onus of proof in civil procedure and civil actions in the High Court. But so please bear in mind, as a general point of departure for any particulars of claim in the High Court, which is the pleading that commences an action, is the particulars of claim. Without that, there'll be no action, ever. So all the necessary allegations to sustain a cause of action must be made. And the reason why this is important, not only for litigants, but also from a judge's point of view, is simply because when the particulars of claim comes across your desk, you need to consider whether, in fact, that this party has made the necessary allegations to sustain a cause of action before judgment can be granted on that. Of course, when there's an opposing litigant, one would hope that he or she would pick that up, but that doesn't mean that the duty is removed from the bench to actually make sure that what litigants are seeking in the court, they've actually asked for in their particulars of claim. All right, then another consideration before we proceed to the actual pleadings is that of jurisdiction. Now, as I've said earlier this morning briefly, the High Court differs from the Magistrates' Court in respect of jurisdiction. Please keep that in mind. It's not only, it really is inherent jurisdiction is a very important principle. I think you'd be well advised to make a note of that. If I'm going too fast and you want me to just slow down so you can make notes, just lift your hand and I'll wait for a moment until you're done. Inherent jurisdiction is very important. So really the High Court has an all-encompassing jurisdiction. It doesn't, to regulate its own procedure. So you'll hear this often, and it's mindful to keep that in the back of your mind while you're approaching the jurisdiction in the High Court, is the rules are there for the court, not the court for the rules. So the High Court is able to deviate from its rules. It's able to determine its own procedure. It's able to hear matters even where really it would fall in the Magistrates' Court's jurisdiction, although that is, of course, disencouraged for various reasons. But that doesn't mean that the High Court doesn't have jurisdiction. So be mindful of that fact. When you proceed to the High Court with a Magistrates' Court jurisdiction matter, you may find yourself, if you're successful, without a cost order in your favor in order to penalize you for having come to the High Court where you should have gone to the Magistrates' Court. So these are issues that are different. Of course, the High Court cannot review its own decisions. It becomes functus officio. So once it's made a decision, it's functus. That goes then to the Supreme Court to review or to appeal or whatever. So it doesn't have the jurisdiction to review what it's already done. So once it's made a decision and given judgment, it's functus, apart from, of course, issues like rescission of judgment and the like, which we'll deal with in a moment. So inherent jurisdiction of the High Court. It's important to understand and establish jurisdiction right from the start because, of course, if the court doesn't have jurisdiction, any order it makes is really worth nothing. So understand the difference between the Labour Court, the High Court, the Magistrates' Court, and the Supreme Court. And whether the High Court, generally, the High Court will have jurisdiction, but there are exceptions, and there are also pitfalls, as I said earlier, cost orders where you should have gone to the Magistrates' Court, etc., etc. Jurisdiction in respect of area, like it is with the Magistrates' Court, it's not the same. So the High Court in Windhoek still has, well, the main division has jurisdiction over any matter as does the inherent jurisdiction. It really is a matter of convenience at the moment. That might change going forward. But for the moment, the parties are able to choose which one is more convenient for them. And you may even ask for transfers, etc. So essentially, it's not the same principles as would apply to Magistrates' Court for that matter, at the moment at least. Then there are a number of very important common law principles relating to jurisdiction, and these you should be mindful of and you should have regard to. I've written them down for you. So it's the doctrine of effectiveness. These are all common law principles relating to whether the High Court has jurisdiction over a particular litigant. So doctrine of effectiveness, doctrine of submission, actor sequitur forum rei, contractual claims, delict, and marriage. These are the most important considerations to keep in mind when it comes to jurisdiction. The High Court has, it's called incula and peregrini. Have any of you ever heard of these terms, inculae and peregrini, if you, just by a show of hands? Okay, so some of you have heard. Okay, it's just really a very fancy way. We want to sound fancy sometimes, so it's really a very fancy way of saying, maybe just write this down and then when you're done, I'll deal with that. Okay, so an incula is someone who is a resident or is within the jurisdiction of Namibia. So incula is someone who's domiciled here, someone who resides here, someone whose permanent abode is in Namibia. Such a person is called an incula. Such a person this court has jurisdiction over, and such a person is also protected by this court and this jurisdiction. All right, that's not to say that an incula cannot be sued in another jurisdiction, but that's not what we're here to deal with. We're here to deal with what you can and cannot do in the High Court of Namibia. So an incula, of course, is someone who is a resident, domiciled here. They return to Namibia as their permanent home or permanent abode. That's an incula. Peregrinus is someone who is not a Namibian, doesn't stay here, isn't domiciled here, doesn't return to Namibia as his or her permanent abode. A peregrinus, and perhaps at this point I could say, the works Herbstein and van Vinsen, which is the civil practice of high courts of the South Africa. It's 2 volumes. I've just brought the first volume today because that's the one dealing with the issues we're dealing with. But this is really a very handy works to have for civil procedure for any person in the High Court. Although it deals with South African High Courts, it really is applicable in Namibia also. There are instances where Namibian case law has developed or where the rules differ slightly, but I mean you are at a level where you're able to read from this works, compare that to the Namibian High Court rules and also look at the relevant authorities to see how it's still applicable or not. Generally and for the greater part, Herbstein and van Vinsen is a very handy works. Erasmus also, Superior Court Practice, but Herbstein and van Vinsen, I could strongly suggest that you obtain a copy and that you use that for civil experience. So Herbstein and van Vinsen has a very good explanation of what an incula and a peregrinus is, but that, as I've just told you, that really is the basic level of what these two are and what they mean. So essentially, generally speaking, the High Court of Namibia would not have jurisdiction over a peregrinus. So if an incula, say I want to sue, and it's not only natural persons, it's also companies, legal entities. Also, whether a legal entity is registered here, owns immovable property, etc., etc. So essentially, there would be some kind of a, when your defendant, not when your plaintiff, but when your defendant is a peregrinus, someone who's not domiciled in Namibia, doesn't fall under this court's jurisdiction, you cannot proceed and simply sue. So this is an important consideration because the High Court may make an order, but that order will be meaningless because it has no jurisdiction over the party against whom it's making the order. For minor children, there's the general rule is that the High Court, as upper guardian of all minor children, even though there are all the acts and all the other procedures and magistrates' court jurisdictions for children, the High Court remains the upper guardian of all minor children. It always has jurisdiction over minor children, except when those minor children leave the borders of Namibia. Whether they are permanently supposed to be with a mother who's a Namibian doesn't matter. Once they leave this jurisdiction, the High Court no longer has jurisdiction over them. Once they leave the borders of Namibia, which is why granting an order allowing a parent, especially where there's a hostile relationship, to take the children out of the country is a very important consideration. But we're not dealing with family law today, it's just something you can make a note of. It may come in handy in future. So there must be some underlying basis of jurisdiction before the court will have jurisdiction over, for instance, someone who's not domiciled in Namibia. So what do I do as a Namibian? I reside here, I'm an incula of this court, and I want to sue a Mauritian company. It's not a Namibian registered entity, it has no property here, but I don't want to go to Mauritius to sue, because why can't I sue in my jurisdiction? What can and cannot, what can I do and what can I not do? So we'll deal with jurisdiction and attachments in a moment, but please bear in mind that it's not that I may simply proceed to issue summons here. Doctrine of effectiveness, so this is obviously one of the considerations the court will take into consideration when considering the issue of jurisdiction, whether it's able to execute the judgment it's going to give. So, for instance, that's one of the reasons why the case law has developed where there's minor children involved regarding an order relating to minor children outside the borders of Namibia, because what can you do with that order? Nothing really. Doctrine of submission, that is what you'll know, of course, in the Magistrates Court Act. There is a prohibition on submitting to jurisdiction in the Magistrates Court Act prior to there actually being a suit. That's actually outlawed in the Act. In the High Court, you can submit. When you're not subject to this court's jurisdiction, you can in contract or after the contract during litigation say, well, I actually like Namibia, I want to come here to sue, or well, to be sued, so I submit to the jurisdiction. And once there's a submission by a party to the jurisdiction of the High Court, then that, of course, gives the High Court jurisdiction. Actus sequitur forum rei, contractual claims, delict, marriage, it's just where the cause of action arose, what the contract says, where the contract was concluded, where it was executed, where the delict was committed. So even though if both parties are here, but the delict was committed in another jurisdiction, one would have to consider whether this court has jurisdiction given what the damages that followed, etc. So these are all important considerations. It really is substantive law, and we don't have time for me to explain all the underlying substantive law principles. Just be mindful that these are the things that you have to be looking at when determining whether a case before you properly have jurisdiction in order to hear the case. Marriage, it's always a difficult issue. A party residing in Namibia would always have jurisdiction to change his or her status in this jurisdiction. What about a situation where the spouse is in another jurisdiction? What about a situation where the parties got married, for instance, in Germany, and the German law is applicable, etc., etc.? Generally the High Court of Namibia, once one party resides and is domiciled here, would have jurisdiction to change the status of the parties. But we'll deal more with marriage and matrimonial causes later on. When the plaintiff is incula, is someone who resides in this jurisdiction and wants a divorce, it's a status issue. And the High Court, of course, has jurisdiction over the matter because it's changing the status of the party. And then you serve. You can serve anywhere in the world. You use edictal citation, and you serve the party there. So the High Court will have jurisdiction, even though it's a foreign marriage that was concluded in a different country. What you cannot do is, of course, forum hopping. So you here, and then you also want to sue in Kansas, in America, and you also want to, because you want to see where you're going to get the best deal. That you can't do. So you must decide the jurisdiction. So you may be resident in Namibia, and you may be an incula of this jurisdiction, and your partner may be a peregrinus. That doesn't matter, because you can still sue by way of edictal citation, and the court will have jurisdiction. You don't need to attach property, for instance, to found or confirmed jurisdiction as you would in other civil causes. So matrimonial is slightly less stringent when it comes to, because the party whose status you're changing is really someone who's in your jurisdiction. And then so much more so when that party is someone who got married in Namibia, and it's a Namibian marriage regulated by Namibian law, but even foreign marriages. But we'll deal with matrimonial causes later in the course. Well, I don't think it's a situation where you don't have to make the allegation, because jurisdiction is always something that you'll need to show, especially when it's in dispute. So the fact that it's not a necessary allegation for other causes doesn't make it an unnecessary allegation in the sense that it should be in the particulars of claim. Why parties always, I suppose, why the practice is developed in matrimonial causes to say that the court has jurisdiction is for that reason, because it may be parties who are actually both domiciled in another jurisdiction. They got married, say, for instance, in Germany. They presently residing in Kansas, and one of them is just coming here for holiday and now wants to sue here because in the Namibian system she's entitled to this, that or the other. For instance, where one party has committed adultery, our law, divorce law currently still states that when you can prove adultery, you can ask forfeiture, and the court has no discretion to refuse in cases of adultery. So to deal with issues of forum hopping, parties who are suing here, who are not truly domiciled here, who are not, if both of them are peregrini, and they got married in another jurisdiction, I mean, the High Court won't have jurisdiction. So it's really a practice that's developed as far as I understand that. All right, so jurisdiction. So two concepts which are very important. I'm not going to deal with the essence of these applications. It may be that Advocate Bassing-Swade will be dealing with these possibly because these relate to motion proceedings, but the principle is also applicable to action. It's to found or confirm jurisdiction. So once again, fancy Latin term, it's to found jurisdiction is ad fundandam jurisdictionem, and then to confirm is ad confirmandum jurisdictionem. Often they are combined. And what this really means is I, as an incula of this jurisdiction, want to sue a peregrinus. It can be a company or a person, a natural person, and I want this court to found or to confirm jurisdiction over this person. So I'm already here, the court has jurisdiction over me. We may have signed an agreement in Namibia, there's some underlying causa or some underlying ratio jurisdictionem, we call it, or it may be that an agreement was executed here, etc., but the defendant is somewhere else. Then we say, Namibian High Court, I want you to have jurisdiction, so I'm bringing an ex parte application, and in that application I'm asking you to attach something that belongs to this defendant that I intend to sue or that I intend to bring an application against. Attach something to found jurisdiction or to confirm the jurisdiction that you already have, because this person is not here, so you may have jurisdiction over the action, but you don't yet have jurisdiction over that person. So found or confirmed jurisdiction, and then I may proceed to sue against that person. What do you attach? Well, that really depends. The point of departure behind this principle, and you'll find a lot of that in Herbstein and Van Vinsen, the point of departure against the principle, or from which the principle of attachment developed, was to attach something within this jurisdiction with which the court can then, which will render the judgment or the order given effective. So it's essentially, for instance, if it's property in value, at least to satisfy the claim that you have. That has been watered down over the years and in case law. And what you generally have today is you can actually attach someone's broomstick. You can attach something of nominal value in order to confound or confirm the jurisdiction. So although the court will take issues such as effectiveness, whether the attachment will render an eventual order effective, that will be taken into account, doesn't mean that because you want to attach a broomstick, you can't do it. So it's really to found or confirm jurisdiction. It's to give inculae of this court the opportunity to sue out of their own jurisdiction. So it really is for protection. That'll be an ex parte application. It'll be a rule nisi simply because it is ex parte. The attachment will happen through the deputy sheriff. It will remain under attachment. There'll be a return date, and then only the papers will be served on the respondent wherever he or she may be. You'll obviously seek relief relating to edictal citation, etc., but we'll deal with edictal citation and substituted service later. And then on the return date, if there's no opposition, the rule will be confirmed, and you'll be able to sue out of this jurisdiction because jurisdiction would have been founded or confirmed through this process. Well, confirm would be, for instance, you have parties who have both were domiciled in Namibia. They entered into an agreement. They executed the agreement here, and the cause of action arose here. So you see how the High Court already has jurisdiction now. One party leaves Namibia. say the defendant now leaves Namibia and he's no longer domiciled in Namibia and he's now a peregrinus for all intents. You can only bring this application against the peregrinus. You cannot bring this application against an incula. There are, of course, defenses to this application by peregrinus, for instance, owning immovable property that's sufficiently unencumbered, etc., but that we're not dealing with at the moment. So you see how there's jurisdiction, and now the one party is left, and so you want to confirm that jurisdiction. Where, for instance, and this becomes the more difficult issue because the question is this underlying this ratio jurisdictionem. So whether there's an underlying jurisdiction that can actually assist a party. Because founding jurisdiction would mean you haven't got jurisdiction, but I want you to found jurisdiction. But what happens in practice is that parties proceed to court saying, do this attachment, court, this is the background, these are all the facts. So either you're confirming jurisdiction or you're actually just founding. So so what you would say is attach the shares in this company ad fundandam, alternatively ad confirmandam jurisdictionem, because you want to cater for both, and that you'll find this all the time. I've never seen in my 14 years any application of this nature in court that doesn't seek both in the alternative. So you need to be mindful of the fact that your facts might seem to you like it's founding jurisdiction, but really it's only confirming, or the other way around. So it really is always, but it's difficult. One of the defenses to this may be that there's no ratio jurisdictionem. So if the only reason why you want to sue here is because you are an incula, it may be difficult for you, even through this attachment, to found jurisdiction. So, but that's something that the court will have to consider, being mindful of all the principles relating to jurisdiction, and whether the court can then say to itself, yes, but I've got jurisdiction because I've attached, I've found a jurisdiction, and the contract was here. Or, so just because one of the parties is here doesn't necessarily mean that the court will have jurisdiction, even through this process. The property of the peregrinus, so it must belong to the peregrinus. No attachment of persons ever in Namibia for any kind of civil debt or civil claim or whatever. It's unconstitutional, and although there may still, through certain practices, be that, in my view, it's unconstitutional to attach a person for a civil reason whatsoever. There is this suspectus de fuga, which is when you think someone is fleeing the country, you bring an urgent application, they're fleeing the country in order to escape their debts. Then there's this arrest and I'm taking you into custody. Whether that will survive a constitutional dispensation, I cannot say. The courts will have to decide. Well, I suppose whether you say it or not, and the court says, I can't give you this because you've only made out a case for that, I suppose you'll be able to amend because you've made out the case. You don't, when you make out your case in your founding papers, and that Advocate Bassingswade will deal with you, you don't need to physically say, so this is an attachment ad confirmandum. You'll set out all the facts, and the court won't bother itself too much with the legal jargon put into affidavits by lawyers. That really is just for it to read well, but it's really the underlying facts that will determine whether you are entitled to any one of these. And you'll be able to amend your notice of motion to say, well, in that case, please confirm your jurisdiction, or please found your jurisdiction. So I suppose it won't be too much of a hassle. It's not a lasting implication. But I, of course, won't advise anyone to proceed to court without doing it in the alternative. Must be in Namibia. Property must be in Namibia. It must be within this jurisdiction. And you must be able to prove that it actually belongs to the peregrinus against whom you want to bring the action. And it must be able to be attached, and that means corporeal and incorporeal. So even shares, claims, etc., all of these are, once it's a right or an asset that's in the form of a right, so corporeal or incorporeal, doesn't matter, you'll be able to attach it, as long as it belongs to the peregrinus and it's in this jurisdiction. The actual attachment of the property is what gives jurisdiction. So as long as that remains under attachment, the court has jurisdiction, you see, because there's something against which they can execute. So it will remain, if the rule nisi is confirmed, the attachment will remain throughout the action procedure up to trial and until the order is given. And then if it's possible that you can execute against it has value, then of course you can that attachment proceeds to by way of a writ, and it's executed against. So it's the actual act of attachment that gives the jurisdiction that you require. No, it doesn't matter what you attach. So whether it's to found jurisdiction or confirmed jurisdiction, doesn't matter what the asset is. So the attachment itself would be the same. So for instance, whether you attach a broomstick or you attach shares worth 10 million, it doesn't matter what you actually attach. Founding jurisdiction would be where, for instance, the only underlying ratio jurisdictionem is one party being Namibian. So it's a foreign contract, foreign entity, foreign execution, foreign payment. Everything is foreign, but one of the parties is here. Or even neither of the parties are here. They may actually both be peregrini. And then one must ask yourself whether this court will ever, even through founding, will ever be able to establish jurisdiction in such an instance. So one of the examples I've recently had, my client is a peregrinus. They want to sue. They want to sue two entities. One is a Namibian entity, and its subsidiary, which is a Mauritian entity. So one is an incula and one is a peregrinus. Of course, the action by my client, who's also a peregrinus, against the incula is fairly simple, because you can proceed where you find the defendant, there you can sue. So this court will have jurisdiction. But the more difficult question becomes when you have a peregrinus and a peregrinus, and now they also want, it's related, so you want to bring that other peregrinus as a peregrinus also into this jurisdiction. So now this peregrinus has shares in this Namibian entity. The shares are here. I want to attach, so you attach the shares to found jurisdiction also against this entity, because you want to sue them together. But now this entity raises the defense to say, well, there's no ratio jurisdictionem because you're a peregrinus, I'm a peregrinus, contract was signed in Kenya, was executed in Mauritius, so what are we doing in Namibia? So that is where the difficulty becomes in. And there you want to found jurisdiction, because otherwise there would be none. And whether you're able to find that jurisdiction, to found that jurisdiction here, is a difficult question. It's a matter of substantive law that you'll have to decide on the papers, having regard, of course, to the substantive legal principles relating to jurisdiction. I suppose I've now confused you even more, but I hope you follow that example. That's a real life example. That's one that I've dealt with fairly recently. It's just because there's an asset here that belongs to a peregrinus you want to sue. The asset itself doesn't need to have anything to do with the claim that you want to institute. Doesn't have, as long as it's property that belongs to the peregrinus, and the property is situated in Namibia. That then deals with founding and confirming jurisdiction. From there, of course, the next issue is that the court may have jurisdiction, but a party who intends to litigate before it doesn't have the necessary locus standi. Again, this generally would be an issue that would be raised by the parties in opposing sides, and would be something that the court then decides on, possibly as a preliminary issue, if it's raised as a special plea, etc., etc. But it's also something to be mindful of for purposes of, for instance, default judgment. So it's important to understand the principles relating to locus standi and to understand how they apply to the civil procedure in the High Court of Namibia. So the meaning of locus standi is simply, and put in most elementary of terms, I suppose, would be to say it is whether a party has the right to sue. Locus standi could never be something raised in respect of a defendant. A defendant cannot decide whether he or she has locus standi. I cannot say, you cannot sue me because I don't have locus standi. That would be an issue of joinder or misjoinder if a party is wrongfully cited. It would be a special plea of misjoinder, may possibly even be an exception, but that's something raised by the defendant. So locus standi is something that you consider for instance, you've established that there is a cause of action. So let's go back to the example I gave you of my husband driving in town and someone bumps into his car, disobeyed a traffic light, and he was now innocent in this whole thing, and this person bumped into his car. Then a cause of action obviously arises in respect of the damage to his car. The court obviously has jurisdiction because the two parties are Namibians, and the cause of action arose in Namibia. The next question is, would I have locus standi to sue based on that cause of action? And the answer is simply no, because I'm married out of community of property and the car belongs to my husband. And I don't have any beneficial interest in the car, so I have no right. So I have no locus standi. So if I proceed to sue for the damage to his car, then I would probably be faced with a special plea or an exception based on my lack of locus standi. So that really is the party who's coming to court, the plaintiff, whether he or she or it has locus standi in terms of the cause of action. So you've established there's a cause, you've established there's jurisdiction, now does the party actually have locus standi? Because if he or she doesn't, of course you can't give an order in their favor because they don't have a right in law to have that order given. So you always ask yourself, does this litigant have an interest in this matter? Now, yes, of course, I have an interest on whether my husband gets the claim back from the money back from the damage to his car. He's reimbursed for that. But that doesn't mean that I have locus standi. So the next question is this interest linked to a legal basis? Now, against this background, before we proceed with locus standi, please remember that the principle is simply orders in the High Court, or any court for that matter, should not be made or handed down against parties who are not parties to the proceedings, but the order will affect them. So it's the same with locus standi. If you don't have locus standi, you don't have locus standi, you can't proceed. You can't proceed with a claim. And if you do, an order will be made that really is someone else's right to claim, and they're not a party to the proceedings. So this principle holds true also for locus standi, although it becomes very important when you deal with joinder and non-joinder issues, misjoinder issues. So you ask yourself, does this person have a interest? Yes, I have an interest in my husband being reimbursed for the damage to his car. Is that interest linked to a legal basis? No. The only reason is because I'm married to him and I want him to be reimbursed. But that's not a legal basis for me to found locus standi. And then if the answer to both those questions are yes, then normally a litigant would have the necessary locus standi. There are exceptions, and these you'll have to determine on the facts as you go along. Experience will dictate to you whether a party has a locus standi or not. But generally, when a party has an interest that's linked to a legal basis, then generally that party will have locus standi. It's a question based both on law and on fact. So in law, a married person might have the right relating to their spouse, but in law it dictates that that's only where they are co-owners or they are married in community of property, or he or she's been appointed as a curator, etc. Therefore, as I've said, you need to establish the facts, and you need to establish what the law is relating to those facts in order to establish locus standi. The issue, as I said earlier, of locus standi can be raised by way of an exception. Exception would be a no cause of action, because you as claimant, as plaintiff, cannot sue me on this basis because you have no locus, so there's no cause of action. Alternatively, you can raise it by way of a special plea. I think it's fairly simple. I think the principles are universal both in the Magistrates Court, civil stream, as well as in the High Court when it gets to locus standi. All right, so now we proceed to action proceedings. And just as a general introduction, because in your course outline, you would see that the next session, which starts on Thursday, Friday, and Saturday, is dealing with motion. And there you'll deal intensively with the question of when to use action, when to use motion. For the moment, I'm just going to say to you, just to place everything in different compartments in your mind, I'm just going to say to you, action proceedings, it's pleadings exchanged by way of particulars, summons with particulars of claim, your plea, your counterclaim, your plea to the counterclaim, replication, joinder, rejoinder, sur-rejoinder, etc., etc. These are the things that are applicable to action proceedings. There's no affidavits filed. The only affidavits you'll find is for interlocutory matters within the trial or within the action proceedings, and then possibly you'll find discovery affidavits and then condemnation. There are these interlocutory issues, but an action is a trial where people get to court, they've filed their pleading saying to the court, this is what we want you to determine, these are the issues between us, now we're going to lead evidence. And the court hears the evidence and makes a decision. That's action. Motion, the parties file affidavits and they exchange affidavits, and these affidavits then form the pleadings and the court makes a decision on the affidavit. No one comes and testifies. It's not a bar all along. There are instances in motion where matters are referred to oral evidence, but that's not what we're dealing with now. So generally, action, exchange pleadings, go to trial. Motion, you exchange affidavits and the court decides on the affidavits and here's argument by counsel. That's the difference. When to use the action proceedings, when there's a foreseeable dispute of facts. So in any instance where there's a dispute of fact between the parties, generally a party should proceed by way of action. And Advocate Bassing-Swade will deal with you relating to what those considerations are. She'll deal with that in detail, so I'm not going to go into much detail with that. But know for now, a dispute of fact will cause you to proceed by action. The sequence of action proceedings, it's an exchange. Action proceedings are always commenced by way of the issuing of a summons. In the High Court, we only have combined summonses. We no longer have simple summons where you file a declaration later, as was previously the position. But for the moment, you just need to know summons starts the action. Then follows a exchange of pleadings between the parties, which may be short. It's just particulars of claim and a plea. That's the shortest sort of pleadings that you get, form of pleadings. Then you can actually get summons, plea and counterclaim, replication to the plea, plea to the counterclaim, replication to the counterclaim, the replication to the plea to the counterclaim, rejoinder to the replication, sur-rejoinder to the rejoinder. So it can be stretched quite far. But it's in my career, I've only once drafted rejoinder and twice drafted rejoinder, once a sur-rejoinder. These are not things that you draft often, but I'll deal with those and tell you when they are applicable. And then once the pleadings have closed, as I said earlier, case management, and once case management and pre-trial procedures are done, the matter proceeds to trial and then you get judgment. The parties in action proceedings are called plaintiff and defendant, or first plaintiff, second plaintiff, third plaintiff, first defendant, second, not ever applicant, not ever respondent. What parties sometimes do in interlocutories, for instance, in an exception or in a summary judgment application, which are matters incidental to action proceedings, they now change the parties to being an applicant and a respondent. That is confusing. I tend not to do that. I tend to disencourage practitioners to do that. They remain plaintiff and defendant. It's an interlocutory, and it's easier for the court to follow that this is the plaintiff and it's a plaintiff throughout, even though the plaintiff is now not the applicant. What you can do is to say applicant/defendant and respondent/plaintiff, but the parties are throughout properly referred to as a plaintiff and a defendant. When should action proceedings not be used? You can always, even if you don't foresee a dispute of fact in motion, you can proceed by way of action. There are certain instances where motion proceedings are prescribed and where you have no choice. For instance, liquidation, attachment ad confirmandum or ad fundandum jurisdictionem. Instances like that, of course, you can't proceed by way of action. It's prescribed that you need to proceed by way of motion. You can have a look at the Room Hire Company versus Jeb Street Mansions matter. The citation is there. I'm not going to go through the matter, but it gives you a good idea of the difference between action and motion and dispute of facts. It's a nice introductory sort of authority to deal with that. I've already dealt with this. So action proceedings, it happens in 3 stages. And please remember that case planning is part of case management, but it falls under the exchange of pleadings part already. So just remember there are 3 parts. We are busy with we're not really at exchange of pleadings yet. We're at preliminary issues, and we'll proceed to the exchange of pleadings in a moment. And then tomorrow we'll deal with preparation for trial. I'll deal with a number of issues relating to trial, and then case management is quite a considerable part of the program, because case management will take up a lot of your time. All right, contents of a summons. Number of issues to consider. As I've earlier stated, only combined summonses are issued. So it's a summons, it's in a particular form, and the requirements are set out in Rule 7, and then it has the particulars of claim attached. Revenue stamp, that's all generated on e-Justice at the moment, so load your credit and your revenue stamp is issued with or placed onto your summons, and e-Justice doesn't issue a summons without a revenue stamp. You'll have to have a look at the requirements in Rule 7 sub 9, because these are really important considerations when you deal with the issuing of a summons. So Rule 9 says a summons must set out the name and, where known, the first name or initials by which the defendant is known to the plaintiff, his or her residence or place of business, and, where known, his or her occupation, and if he or she is sued in a representative capacity, that capacity, and the summons must also state the defendant's sex. So here you're dealing with the citation of the parties in the summons. So we'll deal with that in a moment more particularly, but please be mindful of the fact that Rule 7 sub 9 is the bare minimum. It prescribes the minimum that has to be in a summons. If this is not there, it's non-compliance with the rules. Then also the full name, sex, occupation, and residence or place of business of the plaintiff, and where he or she sues in a representative capacity, then that capacity. If the plaintiff elects to receive any subsequent document by electronic means through e-Justice, he or she must state his or her electronic address and the cause of action and the relief claimed. So these are the things that, so you'll see that it's not a requirement in terms of Rule 7 sub Rule 9 that a party must set out or make the allegation that the court has jurisdiction. But I mean, it is done in pleadings, and it's probably I suppose prudent to do so, but it remains a factor that needs to be determined whether or not the allegation is made in the particulars of claim. You also don't make the allegation that you as a litigant have locus standi, but it remains a question that's relevant to the pleadings. So we'll deal more with contents of a summons in a moment. Citation of the parties. For particulars of claim, you must also see Rule 45. Rule 45 is very important when it comes to particulars of claim. So that really deals with the body of the claim. So citation, Rule 7 sub Rule 9, you must set out at least the surname of the defendant, and where you know his or her first name or initials, put that in. His or her address, where must summons be served. And if you know what he or she does for a living, you put that in. And if you know, and you must put in what the sex of the party is. So generally it would look like this. You have a file, I understand, that's been copied for you that contains examples of a whole case, from pleadings right through to case management. That's a very good reference to have. It's good to work through that. We are not going to work through that specifically in this course, in the sense that we're going to go through all of that, but it's a good reference and example for you to see what pleadings look like, to follow the process and to see how a case develops from particulars of claim right through to trial. So, for instance, in this particulars of claim that I've brought along, the plaintiff is Cipla Agrimed Pty Limited, so it's a company. Then I say it's a private company with limited liability, duly registered as such in terms of the company laws applicable in the Republic of Namibia, and having its principal place of business at 14 Park Avenue, Windhoek, Republic of Namibia, for instance. If it had been a person, I would say the plaintiff is Mr. Joe Soap, a major male, because remember in Namibia you don't need to be an adult, doesn't mean that you're necessarily a major, and if you're not a major you can't sue on your own. So the plaintiff is Mr. Joe Soap, a major male person, currently a major male businessman or a major male lawyer or whatever it is that he or she does, presently residing at number 2 Soap Street, Windhoek West, Windhoek, Republic of Namibia. So closed corporation, you'd say the first defendant is Pro Distributors CC, a closed corporation with limited liability, duly registered in accordance with the closed corporation laws of the Republic of Namibia, having its chosen domicilium Sitandi executandi at Versaghi Plain Bain Centre Shop 23 Pioneers Park, Windhoek. So here, for instance, you have the domicilium. So it's not necessarily a business address or a residential address or a work address. Here, for instance, this particulars of claim is based on a contract, and the parties have chosen domicilium Sitandi executandi, which means the place where I want to be served with any process that may follow from this agreement. And then you're entitled to rely on the domicilium. It's often the situation where you have banks, financial institutions issuing summons against parties for whom they've granted credit and or mortgage bonds that they're foreclosing, etc., etc. Then you'll find that in that agreement between the financial institution and the defendant, there's a chosen domicilium, and then they are entitled to serve on the chosen domicilium, and then you don't need to say and resident there and working there, etc., etc. The Rule 7.9 is the low watermark when it comes to citation of parties. If you don't at least have there what is there and what is known to you, then you haven't properly cited. Where you say in a representative capacity, you would, for instance, have a situation where I'm appointed as a curator bonis for a mentally incapacitated person. I'll sue in my own name. I'll say Chairmaine van Westhuizen, nomino officio, because I'm here in a representative capacity. In my capacity as duly appointed curator bonis for the minor child or the incapacitated person, so and so and so, and I have my registered address here or my place of business here. I'm an admitted legal practitioner, etc., etc. So there also the same principle with a defendant who's sued in a representative capacity. So you'll have Mr. Joe Soap, nomino officio, the duly appointed liquidator of the company so-and-so in liquidation, duly appointed by the Master of the High Court in letters of appointment, and having his principal place of business at so-and-so. Please remember that if you are suing a person in a representative capacity, or you are suing in your representative capacity, then if you don't say that the citation is for a person in a representative capacity, the court is entitled to accept, and the other party is entitled to accept, that the party is being sued in his or her personal capacity, which will have an impact at a later stage regarding to costs, whether the relief is competent against the person in his or her personal capacity, etc. So it's important to know in citation whether it's a person that you're dealing with in a representative capacity. All right, so that I think takes care of the citation of the parties in the revenue stamp. Then let's proceed to Rule 45. If you could just page to Rule 45. Rule 45 has 11 sub-rules. These 11 sub-rules I think you can safely call the golden rules when it comes to drawing pleadings in the High Court. And you need to set out these in your particulars of claim. If you don't, not all of them will always be applicable to you, but some of them are always applicable. For instance, sub-rule 1, which says a legal practitioner or a party to an action, if that party sues or defends in person, must sign the summons and every other pleading. Now, while we're here, perhaps I should say, it's probably important for you to spend a moment of your time reading up on what is considered a pleading and what is not considered a pleading. So a notice of intention to defend is not a pleading. A notice to set up security for costs is not a pleading. These are notices. A pleading is something that's substantive, that takes the main matter further, in the sense that you are setting your case that the court needs to adjudicate. You're setting that out in a document. That's called a pleading. So a pleading would be a particulars of claim, summons with particulars of claim, a plea, a counterclaim, plea to the counterclaim, joinder, sur rejoinder or replication, whichever rejoinder, all those are pleadings. And those are the things that these principles apply to. So of course these principles that you must sign a notice is true also. This rule that you must sign a pleading is also true for a notice. A notice must also be signed by a party or his or her legal practitioner, and that's prescribed in the forms to the rule. But please be mindful of the fact that Rule 45 applies to pleadings in their strict, true sense, and not necessarily to notices. All right, so the division of the court from which the summons is issued, the title of the action describing the parties, and the number assigned for the case by the registrar must appear at the heading of each pleading. But where the parties are numerous or the title lengthy and an abbreviation is reasonably possible, it may be so abbreviated. So these are practicalities in order to make sure that, so you'll see, for instance, in one of the examples, and I have one here, you'll see the first defendant's rejoinder. You'll see in the High Court of Namibia main division. Now this is really an issue of styling, so other people might have it on that side, but the thing is, it doesn't render it in non-compliance with the rules, but this really, I think, is a generally accepted approach to how this is done. So you'll have, this is the defendant's rejoinder. It's in the High Court of Namibia main division. You have your case number there, which is the long one, which is now the e-justice case numbers in the matter between, and then you'll have the plaintiffs there and the defendants there, and then you'll say what it's called. If, for instance, I have 110 defendants, which has happened, you would list them on you may list them on, you can list them here, or you can list them on a separate page and just say between, and then this and others as per Annexure A, and just attach Annexure A. So it's part of your pleadings. But there's no, if you're going to list it in Annexure A, you may as well just list it here. It's copy and paste, it's electronically. But there is a provision in the rules that you may proceed in that way. And then you'll say the first defendant rejoins as follows, and then you proceed with your pleading. And then right at the end, you'll date your pleading. So it will be dated and signed at Windhoek this whatever day of October 2007, and the party signing, which is either the lawyer or the party if he or she's appearing in person. And then you'll send it, of course, to the registrar always, because if you don't send it to the registrar, you may as well just leave it. And then, so it's addressed to the registrar and then to the other party or his or her legal practitioner. That's in broad terms, what a pleading looks like. Every pleading must be delivered. Now, please be mindful of the fact that there is a difference between filing something and delivering something. Filing something means you've served it on your opponent. Delivering it means you've sent it also to the registrar. So delivery requires service on your opponent or opponents and service at the delivery at the registrar. You've served it there. Then only have you delivered a pleading. It's stated in the definitions of the rules. You can check there, but be mindful of the fact that if you don't do both, you have not delivered a pleading. And if you haven't delivered a pleading, the court may ignore it, it's not there. Then sub-rule 4, after the registrar has registered a pleading, he or she must endorse on the first page of the pleading the name of the managing judge to whom the case has been allocated. So that's done by the registrar, and the parties will then know who the managing judge is to whom the case has been allocated. Every pleading must be divided into paragraphs, including sub-paragraphs, which must be consecutively numerically numbered and must contain a clear and concise statement of the material facts on which the pleader relies for his or her claim, defense, or answer to any pleading, with sufficient particularity to enable the opposing party to reply and in particular set out the nature of the claim, including the cause of action, or the nature of the defense, and such particulars of any claim, defense, or other matter pleaded by the party as are necessary to enable the opposite party to identify the case that the pleading requires him or her to meet. So this goes back, this rule, Rule 45, Sub-Rule 5, encompasses really all the substantive law relating to what a litigant is required when dealing with a pleading. So essentially, in dealing with a pleading, a litigant is required to plead with precision, having well prepared for the matter, having obtained all the relevant facts prior to issuing the sum or drawing the pleading, and then drawing the pleading concisely in paragraph form, each paragraph dealing with a main issue. So you would want to say, on this day, say for instance it's an agreement, you'll say, on or about 10 June 2017 and at Windhoek, the plaintiff duly represented by so-and-so and the defendant acting personally entered into a written agreement in terms whereof, and then you proceed with the particulars of the terms of the agreement, the pertinent terms. That would be too much information in one paragraph. So you'll deal with where the agreement, where, when, and by whom, and how the agreement was concluded in one paragraph, and then you'll proceed to the next paragraph because it's the next main point. Now we deal with the agreement. So the agreement, these are the salient, express, alternatively implied in the further alternative tacit terms of the agreement between the parties, and you'll list them. Then you'll proceed to say this was breached by the defendant in that he or she did it, and you list that. And then as a result of the breach, as it was cancelled, you deal with that. Then, so each paragraph concise and material facts on which your case is based. The idea with the new rules is to move away from a situation where you say as little as possible and then you try and build up your case at the trial. A party should know right at the outset what case he or she is required to meet, and that you can only do when you have as much information as possible. So the idea, I suppose, is to move more towards what a statement of claim would look like in an arbitration, where you say more, but you're still not telling a story like you would in an affidavit. So you won't say, well, on Tuesday, 10 January 2017, I walked to, or I drove my car to Baines shopping centre, and there I met so-and-so, and so concise. You'll say, on this day at Windhoek, these parties so represented entered into this contract orally or written. Attached is a copy if it's a written agreement, or if it's partly written, partly oral, attached is a copy of the written part. Then so concise, so all of that whole story, you'll compress it into a paragraph that's coherent, concise, and to the point, but contains all the necessary material allegations. So whether you drove there in your blue Mercedes or your black Land Rover, doesn't matter. It's immaterial, you don't need to put that in there. It might become material later at the trial when you cross-examine and they say you didn't have a car. You say you drove there in your blue Mercedes, but you don't have a blue Mercedes. That might become an issue of credibility, but for purposes of pleading, please remember that you need to keep it concise, consecutively numbered. You should have sub-paragraphs often. For instance, when you say the following are the salient, you don't want to say, you set out where the agreement and how and by whom the agreement was concluded, then you say, it was a term of the agreement that this. It was a term of the agreement that this. It was a term of the agreement. You'll say, the following are the salient terms, either express or tacit or implied, and then you'll put a colon, and you'll say, point 1, point 2, subparagraph 1, subparagraph 2, subparagraph 3, and you list them. And then that's how you set that out. Yes, we were busy with Rule 45. So the nature of the defense. So you must set out, if there's a plea, the plea must set out the defense. You cannot say, I deny, and therefore I'm not liable, please dismiss. You can do that in criminal matters. You can't do that in civil matters. In civil matters, you need to say what your defense is. If you don't, and you just say, I deny, I deny, I deny, I deny, I deny, then it's called a bare denial, and a bare denial is excipiable. It doesn't show a defense, doesn't disclose a defense, and therefore the court's entitled to set that aside if an exception is raised. So there can't be just a bare denial of facts. You need to say, I deny this. Of course, some of them will be just a denial. I deny that I'm in breach, but you've explained that previously, because we agreed actually that I may take 10 months longer to build this house, and they unilaterally changed that, and I'm not in breach, or the agreement should be rectified, or whatever your defense is. But what your defense is, same principle, set out in chronological paragraphs, each paragraph dealing with a core issue, concisely and to the point, and dealing with what your defense is. And then anything else that is reasonable and relevant, and which you need to set out. Remember, if it's not in the pleading, you cannot rely on it at trial. You cannot amplify your pleadings with evidence. You need to set out your claim or your defense in your pleadings, and certain things, for instance, fraud. If you want to rely on fraud or a misrepresentation, you need to set these out in your particulars of claim or in your defense. If you don't, you won't be entitled to rely on it at the trial, and the opponent would be entitled to object thereto and to say, well, this is not in the pleadings, it's not the case that I was called to meet, and which would be, that objection would be valid because it wasn't the case. Of course, then you can amend, and we'll deal with amendment to pleadings and the principles relating thereto and how that has changed with the judicial case management. But for the moment, please understand that if it's not in your pleadings, you can't rely on it at trial. You need to, also through case management, because case management will determine the issues for determination by the court, and that pre-trial order which sets out these issues for determination is based on the pleadings. So if it's not in the pleadings, it'll hardly be in the pre-trial, and it will not be an issue, and the parties are bound by what they set out in the pre-trial. All right, then sub-rule 6. Every allegation in the particulars of claim or counterclaim must be dealt with specifically and not evasively or vaguely. So please remember that in the High Court, where a specific allegation in the particulars of claim or in a counterclaim are not dealt with, it is regarded as being admitted. So if a party or a litigant doesn't plead to a particular paragraph or paragraphs in the particulars of claim or in the counterclaim, those particulars or those paragraphs are deemed to have been admitted by the party omitting to deal with them. A plea then to particulars of claim or to a counterclaim must deal with every paragraph, and it must do so specifically. So you can't say, yes, I know, I take note of this, you must deny, you deal with it, deny it, admit or confess and avoid whatever it is that you need to deal with that paragraph. Of course, you can deal with 3 or 4 paragraphs jointly. So where, for instance, there are 7 defendants and only 1 is you, and the other 6 you don't know, then you say paragraph so-and-so that deals with you, you admit or deny whether you are that person, and for the rest you can say, I have no knowledge if you don't have knowledge, or it doesn't apply to me or whatever, and deal with those together. So where it's of course convenient to do so, you can deal with more than 1 paragraph in your plea. Sub-rule 7, a party who in his or her pleading relies on a contract must state whether the contract is written or oral, and when, where, and by whom it was concluded. And if the contract is written, a true copy thereof or of the part relied on in the pleading must be annexed to the pleading. So essentially, what this is saying is, when you rely on contract, you need to tell the court who entered into the contract, and if it was a company, of course companies act through representatives, or even natural persons may have been represented by someone else. So you must say where, when, date, during or about March 2017, on 17 March 2017, or during about the first part or the latter part of 2000. If your client or the litigant doesn't remember the particular date, and it's for instance not a written agreement, then a more or less date would suffice. Entered into an agreement between the parties, so and so represented. The agreement was written. It can only be in one of three forms. It can either be a written agreement, it can be an oral agreement, or it can be a tacit agreement, which is by, tacit agreement of course, is by behavior. So you can have a combined one of the three. So it can be written or oral, and this is for purposes of this sub-rule. You'll have to say it was a written agreement, or it was an oral agreement, or it was a partly written, partly oral agreement. As soon as there is a written part, whether it's entirely in writing or just a portion of it in writing, the relevant portion of the written part of the agreement must be attached to the particulars of claim. Be mindful of the requirements of the Stamp Duties Act, which states that certain written agreements must be stamped, and if they're not, they may not be presented in evidence in any court of law, which would include the High Court, which means if it's an agreement that's required to be stamped in terms of the Stamp Duties Act, and the copy that's annexed to the particulars of claim is not stamped, then you'd probably not be able, as a judge, to have regard thereto, because it may not be presented into evidence until it is stamped, which means that you're actually not in compliance. You have to ignore it for the time being until it's stamped, and therefore you haven't complied with 45 sub 7. If it's a tacit agreement that a party is relying on, then a tacit agreement, you need to allege the conduct of the parties that leads to the inference that it's a tacit agreement, because a tacit agreement must come about by conduct of parties. All right, so on that note, we'll proceed with Rule 45, Sub-Rule 8 after the tea break. So you are welcome to take your tea break now, and we will meet back here at 11. Thank you.